Thank you. Mr. Speaker, I know we are debating the bill, but I sympathize with my sister, my big sister, Senator Nyamunga, because and I know where that comes from. Senator Petrolina said she's supporting the report. And so, there are varied understanding of the report in terms of its conclusions, Mr. Speaker, because you can't, the chair of the legal committee said it should be amended, and then, all the other issues. So when one is supporting, it becomes, I understand, a contradiction. Mr. Speaker, first of all, I'd like to say that this is a very historic moment. The time we have does not do enough justice to the subject matter that is before us. But be it as it may, I'll try my best to make my few contributions to this very important debate in the country. Mr. Speaker, I stand to oppose this constitutional amendment bill. And Mr. Speaker, my opposition for this constitutional amendment bill is very clear. It starts with, Mr. Speaker, the basics. And the basics for me is the understanding of the popular initiative process of constitutional amendment. Mr. Speaker, there is a reason why there are various processes of amending the Constitution. One is through Parliament, and the other is through popular initiative. Popular initiative, from the tautological understanding of our Constitution making, the 2010 Constitution, and if you read the history, the Yash Palgai Commission report, the Constitution Review Commission, which, Mr. Speaker, I had the privilege of working there for a short period of time, is that, Mr. Speaker, most of the Kenyans were saying, apart from the process of amending the Constitution through Parliament, where the executive and the legislature have a say, we need another process that a common mwananchi can propose for amending the Constitution. Mr. Speaker, why I am very skeptical of this process is because the process of establishing the BBI committee, Mr. Speaker, was not a constitutional review committee. Indeed, Mr. Speaker, in terms of composition of its membership and the structure of the appointment of BBI, it was meant to look at certain issues that are affecting the country, and particularly, we were told to go around the country and find mechanism of uniting the country. We are grateful that one of the members of BBI steering committee is seated here, Mr. Speaker, as a senator. And Mr. Speaker, I must confess that I am aware of how she ended up being in that very BBI committee, the senator of Machakos. And Mr. Speaker, all that process was not intended to amend the Constitution. Yes, Mr. Speaker, that's true. Mr. Speaker, the point to make, Mr. Speaker, here is that even if you go to the members of the committee, even Senator Haji was here and all others, the process was not intended to be a constitutional making body. But, Mr. Speaker, it mutated, and we must accept that perhaps the intenders of the establishment of the BBI committee knew what they were doing, but the rest of the country was not made aware of what was the objective of this BBI process. So we were told, Mr. Speaker, we do this, we go to unite the country, collect views. I am glad the chair of the Legal Affairs Committee has made it clear that even some of the proposals and the report captures on amending the constituencies, Mr. Speaker, was never, Mr. Speaker, proposed by anybody, anywhere across the country. That means, Mr. Speaker, this process was achieved through, Mr. Speaker, in my own opinion, deceit. The people of Kenya were deceived, Mr. Speaker, that this was a process intended in achieving a different objective, but those who had ulterior motives, Mr. Speaker, wanted to amend the Constitution. Why would people who have the institutions and a disposition of the institutions of Parliament and the executive go and use a process that was for common mwananchi, Mr. Speaker, to pass through, Mr. Speaker, these constitutional amendments? I believe, Mr. Speaker, popular initiative in this process has been misused. It's been captured by those who have powers of the state. It is going to be a terrible thing for us to sanitize this approach because, Mr. Speaker, I believe it will not, future presidents will not stop at the current president and those who are in power. Mr. Speaker, future presidents will be doing exactly the same to achieve, Mr. Speaker, what they would call and tell Kenyans it's a legacy. There is no legacy here, Mr. Speaker. This thing is about deceit and deceiving the people of Kenya. Number two, Mr. Speaker, I want to agree with Senator James Orengo that Article 257 of the Constitution does not bar, and the Constitution itself does not bar any of us and Parliament by itself from amending this Constitution. Mr. Speaker, I'd like to read Article 257, and particularly 257, Mr. Speaker, Article 257, 8. A bill under this article is passed by Parliament if supported by a majority of the members of each house. Mr. Speaker, if this house can pass a bill, then, Mr. Speaker, this house also retains the right to refuse to pass or to fail the bill, Mr. Speaker. And, Mr. Speaker, you cannot tell us, because I have had some arguments from certain lawyers, and they are entitled to their opinion because this is a matter of interpretation. But I disagree with them. That, Mr. Speaker, if Parliament does not pass the bill, it is inconsequential because the will of the people is supreme, because this is about popular initiative and therefore the people will have the final say. But it was not the people who initiated the amendment of the Constitution. Mr. Speaker, despite the fact that you collected 1 million signatures, 4 million, 5 million signatures, Mr. Speaker, does not mean it is the people who initiated the popular initiative. Few people in the form of BBI Secretariat, in the form of BBI handshake partners, proposed the amendment. But they want to seek for people's signatures to pass this amendment. If you make an argument that Parliament or Senate can have, passing or failing the bill is inconsequential, Mr. Speaker, then why don't you make the same argument that county assemblies, even if they fail to pass by 24 county assemblies, it's inconsequential? Because it doesn't make it more of the people when it's county assemblies and less of the people when the Senate and National Assembly, Mr. Speaker, refuse to pass the bill. What's my argument? My argument is that, Mr. Speaker, Parliament has a responsibility, and, Mr. Speaker, the failure of both houses of Parliament, Mr. Speaker, to pass the bill as the consequence of failing that bill and cannot proceed to referendum. And I will back my argument, Mr. Speaker, with Article 257 and 257(9), which says, if Parliament passes the bill, it shall be submitted to the President for assent in accordance to Article 264, 256, 4 and 5. Let me make this argument. Mr. Speaker, assuming we were not amending the protected sections of the Constitution, we were not amending devolution, we were not amending structure of Parliament, we were not amending any section touching on human rights or representation. They were just, the amendments that are not protected under 255. And Parliament fails to pass. Mr. Speaker, do you want to tell me that, Mr. Speaker, the President was going to sign it into law, even if Parliament did not pass it? Mr. Speaker, there must be consequences. If both houses of Parliament fail to pass the bill, there must be consequences. And I want to back my argument with Article 257, now 11 and 10. If either House of Parliament fails to pass the bill, or the bill relates to a matter specified in Article 255(1), the proposed amendment shall be submitted to the people referendum. My argument is that for the bill to go to referendum, both houses of Parliament, either both of houses of Parliament pass it, or at least one house of Parliament pass it. But if both houses of Parliament fails to pass, my interpretation of Article 257(10) means that the bill collapses. And people should not fear to refuse to collapse this bill, because we have already debated here, the chair of the committee, minority leader, all the people who have made contributions, Senator Petrolina here, have referred to very glaring, Mr. Speaker, mistakes in this bill. And I'm coming to that argument in a few. So my take is that, and this question was put before the Supreme Court. The Supreme Court ran away from that responsibility of giving advice or opinion to the County Assembly of Nandi and Kericho, and I think the other county was Kajiado. Mr. Speaker, they transmitted back that question to to the High Court, and that question is pending in the High Court. My argument is that these both houses of parliament either pass all of them or at least one house before we can discuss matters of referendum. That brings me to the second argument. Mr. Speaker, many people who have made contributions, including the chair, have talked about unconstitutional constitutional amendments, which is a paradox by itself. Constitutional law experts, Mr. Speaker, and constitutional law practitioners, many of whom are in these chambers, will tell you, Mr. Speaker, the Constitution is what is called in law the gronum, which is, Mr. Speaker, the final law by itself. But, Mr. Speaker, can the final law be unconstitutional against itself? Can you say, Mr. Speaker, for example, an amendment is unconstitutional? What if that amendment passes and becomes part of that gronum? Mr. Speaker, can it then still be unconstitutional? The new thinking, Mr. Speaker, in the constitutional law practice is that, Mr. Speaker, even though the Constitution is the gronum, there are certain principles of the Constitution that carry supra-constitutional status. That is why you hear, Mr. Speaker, the arguments that the basic structure of the Constitution, the foundational principles of the Constitution. Mr. Speaker, for example, you cannot, Mr. Speaker, say, Mr. Speaker, there are particular principles of the Constitution, and our Constitution, for example, Mr. Speaker, which are part of what in law or in Latin called jus cogens, Mr. Speaker, which is the peremptory norm, the norms that, Mr. Speaker, within which you cannot derogate against, Mr. Speaker. For example, you cannot amend the Constitution to legislate torture. You cannot amend the Constitution, for example, Mr. Speaker, even if it is a constitutional amendment to legalize genocide. In the same breath, Mr. Speaker, the constitutional structures itself, Mr. Speaker, must protect the basic norms. What are the basic norms in our Constitution? The basic norms in this Constitution are provided for in Article 10 of the Constitution. And these norms include values and principles of governance, Mr. Speaker. Principles that are like rule of law, patriotism, national unity, sharing of devolution of power, rule of law, democracy, participation of the people, human dignity, equity, social justice, inclusiveness, equality, human rights, non-discrimination, and protection of the marginalized. If these are the basic norms, then we cannot derogate against these norms, Mr. Speaker. Then the question we should ask ourselves, can the amendments that have been proposed in the BBI report pass the test of protecting the basic principles and values of the Constitution? Mr. Speaker, put in another way, is it possible for us to bring constitutional amendments that, Mr. Speaker, contradict the basic norms of the Constitution itself? For example, Mr. Speaker, we've said that in Article 81, that, Mr. Speaker, we must have gender equity, that all institutions of governance, including Senate National Assembly, must have, Mr. Speaker, at least a third of its membership, Mr. Speaker, must come from either gender. But we've come with the BBI report and said, Mr. Speaker, that we are going to amend the Constitution so that in 2032, and I don't know why the women folk who keep talking about here that there are many gains of women in this bill. This BBI report says in 2032, if we will not have achieved a third of women in the National Assembly, a third of women in the county assemblies, that will be the end. That will be the end of gender, Mr. Speaker, principle in our constitutional order. Meaning, if the county assembly of Elgeyo Marakwet elect 20 MCAs, Mr. Speaker, that are all men, there will be no nomination in 2032 because the principle that is the BBI report will only operate for 10 years. But ask yourself, Mr. Speaker, can you then provide that amendment that takes away that gender principle and still retain Article 81 of the Constitution that says at least a third? In 2032, we will have a problem. And the problem will be this amendment is sitting on what foundation, Mr. Speaker? Mr. Speaker, another example I would like to give is that, Mr. Speaker, you have, I am a bit, Mr. Speaker, disoriented because I've seen the time is running. But, Mr. Speaker, I'd like to give one more example. That, Mr. Speaker, you have a provision that says there must be equity in share of positions in government and representation in constituencies. Is it then fair, Mr. Speaker, to say that responsibility is left to IEBC in Article 89 of the Constitution, but go to the schedule of the Constitution and look, some of the constituencies, and for this matter, 70 of them, away, Mr. Speaker, from the discussion in the principles of Article 10 that, Mr. Speaker, it must be distributed fairly. Mr. Speaker, the same question would be asked in terms of, Mr. Speaker, the question of the provision of the ombudsman position. I saw the chair of the Legal Affairs Committee struggling, trying to justify, Mr. Speaker, that the ombudsman, yes, will be there. He will be there investigating judges. He will be there intimidating judges, Mr. Speaker. He will be there giving calls and telling judges, if you don't do this, if you don't do the other one, you will be removed. But then ask ourselves that, oh, the Constitution allows JSC to retain its power, Mr. Speaker, to investigate and interrogate judges. How will the two provisions sit together? How do you bring constitutional amendments that contradict the basic structure of the Constitution and the basic foundation of the Constitution in terms of the values and principles, Mr. Speaker? It is, Mr. Speaker, these glaring constitutional contradictions that you find in SRC provisions, Mr. Speaker, as the chair has talked about, that you find in Article 203 of the Constitution. Article 217 says, on division of revenue, Mr. Speaker, there must be equity. And you must take care of the constituencies and the counties that are, Mr. Speaker, marginalized for a long period of time. Then you bring a constitutional amendment that says you cap, Mr. Speaker, the resource they will get in terms of the per capita, Mr. Speaker, in terms of the population. Mr. Speaker, the question you ask yourself, is it fair after the effort we put, Mr. Speaker, this last year on division of revenue, that now we go back and take away these gains from counties like Lamu, from Tana River, from Wajir, from Garissa, Mr. Speaker, and we happily sit here and say these counties can lose money anyway, and we are putting that principle in the Constitution. I understand why the chair was struggling. He was struggling, Mr. Speaker, because he was saying, we will leave that to interpretation. Let Parliament, when it comes, Mr. Speaker, why would we put ourselves in this kind of situation where we are amending the Constitution, knowing too well that, Mr. Speaker, most of the provisions of the Constitution are assaulting the basic structure and the foundation of the Constitution? Why would we do that? So that then a few people can achieve their political objectives, Mr. Speaker, at the expense of the principles and values of the country. I submit, Mr. Speaker, that even though time is too short for me to make this, can I request 2 minutes, Mr. Speaker? Only 2.
No, just finish because it's you're almost
so that I conclude.
you are wasting what you already have.
I know it's going to end in a short while. Mr. Speaker, my submission will be this, that, Mr. Speaker, the Constitution does not prohibit this House or the National Assembly to amend this bill. And whatever is not prohibited by this Constitution, and I've read Article 1 to the last article, Mr. Speaker, even to the schedule, since these provisions are not prohibited, and I want to declare, I want to tell Senator Orengo and all the senators who are here, Elgeyo Marakwet and the region I come from, the Rift Valley, loses nothing if, Mr. Speaker, this bill passes as it is. But, Mr. Speaker, I'm not the senator of only one region. We must look at the country as a whole. I come from a region who perhaps has received their fair share of an extra constituencies, and we are happy with it. But, Mr. Speaker, I'm still unhappy with the bill. Why? Because I am a senator of Kenya. I believe, Mr. Speaker, that when Kenya is well, when all of us are well, no one should look at Murkomen and look my political disposition or where I come from and think, okay, there are certain things that we are going to lose. Mr. Speaker, I was in Yes campaign in the 2010 Constitution. I worked with people like Senator James Orengo. And, Mr. Speaker, we passed the Constitution. But the people who benefited most when the Constitution passed, including the Deputy President, were in no. Being in no, Mr. Speaker, and Mr. Speaker, defending basic issues that are about this Constitution does not mean you are going to be personally at a loss. So if people are going to force on us this Constitution that it must pass by force, I want to go on record as one of the citizens of this republic to say these amendments in the BBI report, Mr. Speaker, are clawing back the gains we achieved on 2010 Constitution in terms of independence of the judiciary, in terms of principles of separation of powers, Mr. Speaker, in terms of bringing matters related to executive, Mr. Speaker, to Parliament, so that you will have one constituent that has a minister, Mr. Speaker, and another one that doesn't have, Mr. Speaker, creating inequality. If we really wanted to change the structure of government in this country, why didn't we go straight to parliamentary system of government? How are we going to sit the amendments we brought here for certain few members of Parliament to come to become cabinet?
Okay, your time is up.